that public facilities had to be in place. There was nothing that required them to analyze the impact of the development that they were approving. Uses, a few dimensional standards, that's all they had to do with zoning, right here. And they did it with no constraint. And so we started seeing overdevelopment, and the legislature could take this away from them, right? The legislature could have dissolved all the cities if they wanted to. It's all under the control of the legislature under our state system. But some of the truth that led us to this point remained true. The city governments were still the closest to the ground. They were the closest to the issue. They were really the ones who should continue to regulate land use. But they needed to do it they need to get their eyes up off their immediate community and start looking at it in a more comprehensive way. So the legislature imposed on them a comprehensive plan requirement. Let's see if I can spell. All right, and it comes over it. This is the historic form of the regulation. It's been in existence since the beginning of the 20th century. It operated, but it didn't give consideration to the bigger issues, so the comprehensive plan was imposed on them. And the requirement, even though this historically existed before the comprehensive plan, the requirement was city, county, you must adopt a comprehensive plan. It must meet minimum standards. We, the state agency, are going to review it to make sure that it meets these minimum standards. And then you have to make your zoning and land development regulations consistent with it. So even though this existed first, the zoning had to become consistent with the comprehensive plan. So when you're reviewing a piece of property, in Florida or in a state that has a comprehensive planning statute, the first question is, what is the land use designation? Because that's the overriding control, and that's the most difficult thing to change. And then we get down to the next layer of zoning. And over the course of time, local governments in Florida, after they adopted their comprehensive plans, they went back to their zoning codes, and they conformed their zoning codes to the comprehensive plan, and they integrated them. But initially, once the comprehensive plan had to be adopted, there could be conflict, where uses that were permitted by the comprehensive plan were not permitted by the zoning. Uses permitted by the zoning were prohibited by the comprehensive plan. It was kind of a mess for a while. But they had a period of time to bring their land development regulations, and that's the more generic term. What we call zoning is one type of land development regulation. Sometimes they don't use the zoning term at all anymore, but, and that's the hierarchy. The state legislature adopted a state comprehensive plan with very, very broad goals about we like this and we don't like that. And, we like tourists, but they have to be accommodated and directed to the right areas of the state, big general things. And the statute required local governments to adopt comprehensive plans. Now, a statute had been in place in Florida since the 70s that required cities to adopt comprehensive plans, but they just didn't do it. There were no teeth to it. What happened in the 1985 Growth Management Act is that the state finally put some teeth behind it. And what they did is they said, if you don't adopt a plan when you're required to, or you adopt a plan that's not consistent with our rules and you don't fix it, we're going to withhold all your grant money. And that was teeth. That was enough. And eventually, and really, everybody got on board. And it was like the professional planners, full employment act too. Because lots of cities that didn't have professional planners on staff suddenly needed them. But it added a mandatory requirement, and then the legislation also said you must conform your zoning to your land use, so that all of your decisions about zoning and development approval are consistent with the comprehensive plan. And what that means is that you're going to it has to further the goals, objectives, and policies of your comprehensive plan. And that's the analysis some of your projects involve land use plan map amendments. And that's the question of whether the amendment to that comprehensive plan is going to further the overall goals, objectives, and policies of the plan. And so that's how it came about. And then zoning and other land development regulations, which might be subdivision regulations or tree protection ordinances or landscape codes, all have to conform. They all have to be consistent with the comprehensive plan. And concurrency, as we defined earlier, was the sort of ultimate implementation. That the old way of approving projects gave no consideration to impact on facilities. It was driven by the need to grow tax base, to have money to build facilities, but there was no direct correlation as to how many cars you were putting on the road, how many gallons per day of water and sewer were going to be needed. And there was this disconnect. The Water and Sewer Agency was building, developing, growing their plants with no connection to the development approval process that was going to actually put those units into the queue to need the equivalent residential units out from the utility provider. So the comprehensive plan required those to be connected. And it brought professionals into the process when previously, you know, if the mayor liked your project, you were going to get approved. And there was no professional analysis behind it. Yeah.
So in the planning stages of it, instead of comprehensive plan, for utility agencies, say a water sewer department, for example, would they reserve the land around it, the current facility, just to, I guess, be able to, you know, expand as market?
One of the interesting things about the comprehensive plan that went so far beyond traditional zoning were the idea of elements. In addition to the land use element, a comprehensive plan must have other elements, including a capital improvements element. So if the city is also the water and sewer provider, as part of this planning process, they had to create a capital improvements plan that would contemplate how fast they needed that capacity and how they were going to add it in time to meet the need. So that capital planning process had to be integrated with the land use process for the first time. And parks, the same way. Schools kind of lagged behind, but eventually school planning got into the process also. Schools are not controlled by local governments, but school boards, so they kind of ran on their own set of rails for a very long time, but eventually they became integrated too.
So those utility agencies, and under this process, they would create easements, so that's where the whole idea of easements came from as part of the comprehensive plan, is that correct?
Well, easements are just a property right. They're not particularly unique to government or to planning, but you see utility companies did not need comprehensive plans to get the easements they wanted. They could get the easements they wanted because you were not going to get water until they were satisfied. So the water and sewer installations, getting the utilities to the site was never the problem. It was the capacity. When the land use planning was not integrated with the capital facility planning for the utilities, you might have a line connecting you, but there would be no water because they hadn't planned ahead on the facilities. So the easements they could get without planning. They could just blackmail you and say you're not going to get your water turned on until I have my easement. But the planning was necessary in order to get capacity online. Yeah.
So my understanding is that, you know, most developments address this through paying these impact fees, in which we pay the government X amount for however much we're going to build, and if that includes a water line that is bigger, it's going to be a higher cost. Of course, are you saying before the comprehensive plan they didn't pay any impact fees? Is that
they
or
did.
is it just not? They weren't addressing some sort of comprehensive.
They might pay impact fees, but the utility wasn't guaranteeing them that it would be there in time. You know, it was, and a utility is a money-making enterprise, even when it's a government enterprise. Money-making. They have to recover their costs. They're run like a business. Let's put it that way. But utilities would do their best because it was in their interest for their rate structure to deliver service whenever it was needed. But when there was no communication between the development approval side and the capital planning side, they sometimes were not prepared. They could not deliver the utilities in the time frame that the developer wanted them, and yet the developer had entitlements in hand. Or they pulled capacity away from somewhere else. It just wasn't coordinated. And it happened a great deal with drainage. Drainage problems developed because individual projects would get approved and they would have to meet building code standards, but they were disconnected in the review process from their neighbors. And drainage and stormwater recharge is another element of a comprehensive plan that now has to be integrated with all of this. So a developer is asked not only how many units and where and what's it going to look like, but tell us where you're going to get your water and sewer and give us a letter to demonstrate that they have capacity to serve your project. Tell us where you're going to drain and give me a letter or a conceptual approval from the drainage district that they're going to receive your stormwater. All of that becomes integrated under a comprehensive planning system.
So, like for a couple projects I worked on, a couple of municipalities required capacity reservation fees. So that would be a good use for municipalities to kind of forecast when, at what point in time, the capacity would be maximized.
Yes?
Or-
So they know when they need it.
Exactly.
A good example of this is in Covenant Grove, where I'm from right now. They're putting 5 residential condo towers on Bayshore Drive, and during the first 2 REE bill, I lived right next to it. They had to tear up 27th Avenue and put in all new water pipage and drainage pipage to handle the capacity. And on top of that, they expanded the road while they were digging up all this, but throughout the grove now they're just tearing up the roads and putting more sewage and water pipes to handle all the people that are coming in. Luckily, they started the construction as the first 2 condo towers were going up, so I guess they all talked and got everything together.
But better that they do that work to
Now-
build the lines to take the capacity than that they just tap into
Yeah.
things that don't have capacity. Portia, and then
Just out of curiosity, so I know that you said between 1970 and 1985, there were rules and people weren't following them. What was the pushback? I kind of wonder if maybe comprehensive plans for some counties are not necessarily a bad idea, but like I drive around Palm Beach County, like Delray, West Palm Beach, and you see dozens of shopping centers just empty. And it's like, well, maybe the county knew better. Maybe it's like, okay, we could put a plan together, but what happens if a situation like that happens where there's empty shopping centers? We could have used that for residential, but now we have to go through the whole process to rechange our comprehensive plan.
I mean, there's still somewhat of a disconnect between the private market and the planning process. There's nothing that says that the fact that commercial is approved on a corridor, that there's going to be a market for it. Okay, that's just the government planning process is really looking, it's planning. It's not looking at the business side quite so much, although they're doing more of it now. But that happened. The fact that there were a range of uses and what got built was something that wasn't sustainable in the market. Is it the fault of the plan, or is it the fault of the developer who didn't hire the likes of you to do the pro forma better for him, right? That's what I mean, that's where the private meets public. And one last thing before I get to your question. In Fort Lauderdale also, for very, very strong planning requirements to do mixed use and to front the buildings, you know, in the eastern core of the city, to front the buildings on the street, to activate the pedestrian area, and to do ground floor retail with office or residential above. They want ground floor retail, ground floor rent. They're beginning to learn. They're learning also that in some areas, that's going to sit empty, and they don't want it to be empty. So they're starting to work a little bit more cooperatively, with the contractors with the developers on identifying the projects where the ground floor retail is really going to get utilized. It was a great concept to everybody have ground floor retail, but not if you can't get tenants. So they're trying, but it can happen. What are you going to say?
Yeah, I'm wondering to what extent the comprehensive plan is a living document to recognize current day issues because, for example, in downtown Miami, transportation is a major issue right now for congestion and gridlock and all of that. And there are no impact fee assessment defined anywhere in the comprehensive plan or in the approvals, zoning approvals and all of that for these development projects to go ahead. And once they get built, the gridlock and all of that is just exacerbated. So to what extent are these comprehensive plan living document to recognize those shifts and changes so that proper accommodation can be made?
Well, changes, a comprehensive plan, like a constitution, is the most difficult thing to change. In the early stages of and I'll get to a history, let me just see if I can find it. Oh, this was a picture. See, Growthzilla, that's what I was describing. That's thanks to our friends at 1000 Foot Florida. This is the relationship of pieces. So I'll run you through this history next. But I remember the question. Okay, so early in, after the 1985 changes to the law, when comprehensive planning became really serious, there were controls also put on how often a plan could be amended. They were limited to 2 times per year, with very few exceptions. And the process, there was a long process to amend a comprehensive plan. You had to go through a public hearing to transmit it while everybody's thinking about it. And then it comes back and you go through another public hearing to adopt it. And so there's a sense in which you don't want to change the comprehensive plan as easily as you could have changed a zoning code, which is just an ordinance. They want there was pressure to limit the number of changes to a plan. So first of all, so you look at it fully and comprehensively before you adopt it, and then you don't change it on a whim. It's like the Constitution. But they can be changed. And some of the changes, I'm more familiar with Fort Lauderdale certainly than downtown Miami, but the city of Fort Lauderdale has a downtown regional activity center, it's called. It's a land use designation that draws a line around the downtown, and it doesn't micromanage within it. It says you can have all these certain uses, and you can have all these units and all this gross square footage, and from the comprehensive plan perspective, we don't care where you put it. It's within a bucket. Here's your bucket of urban development, and we'll set a maximum on the bucket, but within that, it can come up, it can grow in many different ways. In downtown Miami, I happen to know that they completely eliminated required parking for residential. Okay, so it may make you want to pull your hair out, but what it says is there's a change to policy, and to make that kind of change to a comprehensive plan, there's a policy, there's a thinking behind it of we want to get people out of their cars. We do. We want to make parking downtown so horrible that you don't even try to do it. You don't have a car, or you leave the car in the garage most of the time and you use Metro Rail. And by saying there's no required parking, it's contemplating. It's, as a policy matter, it says, we think that's the kind of downtown we would like to have, where people don't have to drive. And those kind of policies, you may not like them, but a plan can be amended to change the vision for an area in one of those big ways. Like I said, downtown Fort Lauderdale, they're about to add another, 6,000 units or something to the downtown regional activity center in Fort Lauderdale.
Yeah, but the problem I have with that is it's all well and good to say that we want you out of your car, but if they're not providing any alternative for mass transit because the funding isn't there, then how do you solve the problem? And this is why, I'd like to suggest a special impact fee from all developers dedicated to just transportation issues, rather than, impact fees for water and sewer and all of that. They need something dedicated to transportation.
In the statewide comprehensive planning process, we've seen movement in that area too over the years. So let's look at some of this history. Back in 1972, the Florida Land and Water Management Act. So this was at at a statewide level, started establishing statewide policies that were supposed to filter their way down into the local government decisions. At that same time, a statute was enacted that called Developments of Regional Impact. I know some of you have experience. Who's had experience with a DRI before? Yeah. So a Development of Regional Impact was something that the state did because the local governments weren't really doing this very well. Okay, it established thresholds for large developments. So for certain uses, if you had more than 100,000 square feet of commercial, you'd trigger a threshold for DRI or whatever it was. I didn't really work as a private lawyer when developments of regional impact were in their heyday. I was still on the government side. So I don't know these thresholds the way that my partners do, who wrote most of the DRIs in the state. But there were thresholds for different uses that said, this is what we think makes it a big project, a development that has regional impact, not just local impact, but regional impact. Or if it was going to put so much traffic on the roads, if it had so much parking, if it was a certain kind of use like an airport or like a regional mall of a certain size, it would trigger a threshold that would take the project out of the sole hands of the local government, not completely, and say we're going to look at this regionally, and we're going to control the development approval in a more regional sense. We're going to force you to look at all the issues that your local program doesn't seem to look at adequately. So while the cities were mumbling around here, enforcing their own zoning laws and not thinking regionally, the state legislature adopted some land planning statutes, including the DRI statute, to try to get regional planning and large-scale planning to be performed on the bigger projects at least. And then 1975, the first Local Government Comprehensive Planning Act. And that was the one that I said never really got enforced because they didn't have any teeth. So then along comes, in 1984 and 1985, we get the state and regional planning acts adopted, and 1985, the road management law that we've pretty much been operating under since, which made it mandatory and threatened local governments with administrative enforcement actions and loss of grant funding if they didn't adopt comprehensive plans. Okay, so and it included these elements. Future land use is what everybody focuses on because that tells you what uses you can build and where, and that's what was covered by zoning. Future land use elements were familiar, but these other elements that analyze the natural resources, it forced the local government to look around them and recognize when they had natural resources within their jurisdiction that needed protection. They wanted to close their eyes and approve the project that they liked, but they were forced to say, well, where do we have wetlands and do we protect them? Where do we have, I'm not much of an outdoors girl. What are natural resources worth protection? There's water, there's upland, there's wildlife protection. Mangroves, all that stuff. The capital improvement schedules that we were talking about, forcing them to plan for their future. So, and this was technical things. They had to look at their land use map and assume that it gets built out at full density and understand what the population of that would look like and plan their capital improvements to meet that population. This was real serious analysis.
Well, transportation is missing from there.
No, road concurrency. There's a yeah. The 1985 Act did require a transportation plan. Failure on my slide, not in the act. Okay. And then they started tweaking it. So one of the problems with resource protection is that sometimes regulation wasn't enough. The land needed to be acquired for protection purposes. So they did Florida Preservation 2000 to fund acquisition of natural lands. We're going to spend more time in a bit on regulatory takings again. but there was the Burt J. Harris Act. It provided a money remedy for regulatory impacts that didn't rise to the level of a taking. And then throughout 2000s, there was tweaking of the growth management law. And don't worry about the details of this, and you're going to get the rest of the PowerPoint anyway. Now, where we are, when did Governor Scott get elected? We're in his second.
Second term?
We're in his second term now. When was his first?
2010.
2010? Okay, so we get, Governor Scott comes in and decides that the land development issues need to be approached on the basis of development opportunity. He changed the name of the department that had regulated comprehensive plans from the Department of Community Affairs to the Department of Economic Opportunity. And so his influence, they changed the whole focus. And there's been a process since then of the state control of comprehensive planning has been released bit by bit back to the local governments. The law is still there that requires the local government to have the comprehensive plan and to address all the issues, but control is falling back to the local governments again, and there's much less state involvement than there used to be. Amendments to the comprehensive plan can be done on a much more expedited basis. The state agency can only get involved if it rises to a certain level. So there's a lot. We're back to local control in many, many ways. But what's happened in between is that all of those cities have adopted comprehensive plans. They've all learned to use the tool of comprehensive planning to guide their community. They all have professional staff on board now to do it, and they're more competent to perform that zoning function that they've been doing since the turn of the century.
What was the final word on density? Because the comprehensive plan usually it's very
Generic.
limited and numeric about the density per acre, number of dwelling units or residence per unit. And then the villages have their own minds about what should be going into their little cities. And when you go back and forth from the city to the village, who has, I assume it should be the comprehensive plan, the county, who has the final decision. But it's like a loop where nobody can actually make a decision.
Density, the comprehensive plan, the controlling comprehensive plan must address density. It has to address intensity of use on the commercial or non-residential side, and it must address residential density. So the first question is, whose plan? Because there are some, in most areas of the state, there will be one comprehensive plan that controls. If the property is located within a city, it is the city plan. That is the comprehensive plan that controls. If you're located in the unincorporated area, the county plan is the one that controls. In some areas, by charter, there will be multiple layers of control. And Miami-Dade County may be one of those things where the cities within Miami-Dade County must conform their plans to a county-wide plan. In Broward County, that is true. By charter amendment, there is county-wide comprehensive planning authority, and cities must conform to the county plan. So the process to change density means go to your city and get a plan amendment approved, go to the county and get the plan amendment approved, go to the state and find out that nobody objects, go back down to the county, get it finally approved, go back down to the city and get final approval. That's how you would change the density.
But in the case of specifically a city in Miami, a villa, that you're supposed to go there first in order to change the density. But they say no. On the other hand, the comprehensive plan from the city of Miami states that in certain areas, and it's delimited by the Miami 21, densities should be increased because of walkability and all this. So if your first step is to go into the city, the villa, and then go to the county, which is what governs the comprehensive plan. You never get there because the city's telling you no, but it's within the, so it's, you find in a loop, you know, like that.
Well, you're not in a loop, you're just not getting the answer you want.
Can you sue?
Okay? Because the fact that a comprehensive plan permits density up to a certain level, most of those plans also say you're not guaranteed the maximum density. For neighborhood compatibility purposes, for any number of purposes, we can keep you below the maximum. It's not a guarantee. Some of them, you know, some zoning designations and some plan designations do have a minimum because for reasons, as you said, they want to direct development, you know, urban development, they want to direct it to urbanized areas. So they're not going to let you go into the urban core and build 2 units per acre. All right, there will be a floor. But most comprehensive plans do not have a floor on density. They have a cap. And they say it's no guarantee that you're going to get the maximum. So that's what you're encountering. They're like, yeah, the county plan might permit up to 10 units per acre. But we think this is I'm just making this up. We think this is a transitional area between the high density and the low, so we're going to keep you to 6 units per acre as a transition mechanism. That's a legitimate decision.
But the final word is in the village. I mean, they are the ones who decide, because it'll be contemplated as zoning kind of regulation, because the villages are supposed only to govern zoning, right?
The what?
The little cities, the cities within the cities.
They have to do, every city has to do a full comprehensive plan with all these elements we've been talking about, every single one. They do. And most of the time, that's the controlling plan. In some parts of the state, because of the county charter, Miami-Dade might be one of them, Broward is, Hillsborough County is, Jacksonville is, the city plans must conform to a countywide plan too. So and again, I don't know that particular situation, but the comprehensive plan usually says, if this is the designation, this is your maximum density, but we can reduce it through zoning. Okay, it's like the Constitution, it's overriding, and there are many regulations and limitations that can fall beneath it. So that's how we're getting to where we are, and yet this is much more the process. Hang on just a minute. The process for adoption and amendment of comprehensive plans has become much more local again. For everything except the very biggest projects that would have been DRIs, the local government prepares an amendment, they send it to the state. If there's no objection from state agencies, they just go ahead and adopt it, and that's all there is to it. So it's called expedited review now for most amendments.
I'm just a little confused. So is the state review still in effect when you make zoning changes at the city level, or is that only for big like DRI or like DRI?
There's no state review for zoning changes. There is state review for comprehensive plan changes. And those, most of them are done on an expedited, what's called expedited review, which means you only hear from the state if they have an objection.
So what essentially is the actual land use map? Is that amendment to the comprehensive plan?
It is a map, it is. But there's also typically a zoning map. Not always, sometimes they combine them, but you could have, so let's think. A city might have a land use map with 3 different intensities of residential development. You know, 5 units per acre, up to 10 units per acre, up to 15 units per acre. But that's what they have in their comprehensive plan. But at the zoning level, they've got much more granulated. You know, 2, 3, 4. They've got many zoning districts within each of those comprehensive plan categories. Following me? No? Look confused. So, something like this. You know, I'm having anxiety flashbacks standing up here as a teacher because I used to have anxiety if I had to come up as a student. All right, so we've got 3 different categories of residential with different densities in the comprehensive plan. All right, 15 and 5 units per acre. That. But then for zoning, they could have R1, 1 per acre, R3, 3 per acre, and multifamily 5. It gives you 5 per acre. All of these zoning categories would be permitted by this land use category. And I'm only using residential because it's a little easier. So if you want to change the zoning on some R3 to multifamily 5, doesn't affect the land use plan at all. But if you want to do a 22 unit per acre, you want to do some big project that has 22 per acre, you've got a problem, because there's not even a land use category that permits that density. So you have to go do a text change to create a new land use category that permits 25 units. And then they have to adopt zoning that's consistent with 25 units. The land use plan amendments that create the category and that apply the category to a map, those go up for state review. But the state, they either, if they have no objection from state agencies, they just let it, they just do nothing at all, and the city adopts it and it goes into effect. Now, I mean, there are things that this statute says about these regulations and about these zoning decisions. They have to be consistent with the comprehensive plan, or a private property owner next door, anybody who's affected by it can sue because you've done something consistent. Let's say we're in this world and you come in with this great 22 unit per acre project, and the city loves it, and they just simply approve the project. They didn't fix the land use, they didn't fix the zoning. They can be sued for violating their zoning and for doing something, adopting a plan, approving a development that's inconsistent with their comprehensive plan. And anybody who's affected by it can file that lawsuit. And the claim is simply, you're doing something inconsistent with your comprehensive plan, and it can be invalidated.
So taking that example you just did, applying that at the city level, if the county had a zoning ordinance that allowed 25 units per acre, does that skip the state review because it's part of the county's comprehensive plan?
No, if you're in, let's say, and I'm going to talk to Broward County because I know it better. Okay, you're in Broward County, and the Broward County has a land use designation that permits 15 units per acre, and your city has a consistent land use designation that permits 15 units per acre, but you want to do your 22 unit project, you have to amend the city plan and you have to amend the county plan and then get the zoning in place for your 22. The fact that a city, when a city has to be consistent with the county plan, it can't exceed the maximum density and intensity that's permitted by the county plan.
For the city.
For the city. I don't, it's still not
Doesn't matter which one's first, whether you go to the county and get it approved, or go to the city, or just.
Theoretically, in counties where county plans and city plans must be consistent, and the county plan, is kind of over the cities, they're already consistent. Let's say they've done all this and they're already consistent. So if you want to change it, you have to start at the city and then go to the county, and then the state says they have no objection, and then you get adopted, and then you can move forward. Again, in most parts of the state, if you're located within a city, you have one government to deal with. It's the city. The county plan only applies to the unincorporated area. In Palm Beach County, I believe it is that way, for example. There's no charter provision that gives the county authority over the land use regulation within cities. Most areas of the state, if the property is within a city, that's the only comprehensive plan you have to worry about. In a few areas of the state, like,
Nice under the state, the counties, the cities only plan on.
under the state, yeah, there's no county plan consideration. But in Broward County, for example, we have a charter that says that the county has countywide land use plan authority. Boom, there you go. So the county plan, is the city plans have to be consistent with the county plan here in Broward County, and I think Miami-Dade might be the same way, but again, I'm not a Dade County person, so.
I have a question about consequences. Assuming those inconsistencies exist and the zoning officials grant approval to a developer who is aggressively gone ahead and develop, and then it is revealed later that those inconsistencies exist and perhaps the state is going to take action, who suffers the consequences there? The developer is proceeded.
The developer.
Wow.
I mean, there's one case, I think it was in Martin County, that the developer got a land use plan amendment and it was challenged by neighbors. It increased the density. And while the administrative, there are two paths. Certain things you can file suit in court and other things you go through an administrative challenge for. And I think the state, that was in the time period when the state had to affirmatively approve an amendment, not just take a pass on objecting to it, but they had to affirmatively approve it. And the state objected, and so while the challenge to the plan amendment was going on, the developer proceeded and built the project and had to tear it down when the plan challenge was upheld. So the legislative scheme that says thou shalt not permit development that is inconsistent with your comprehensive plan is serious business. And it's why when people are buying land, they often wait until all of those entitlements are done before they close.
Well, to go back to his question, let's say one level, the first level, I mean the city granted me the permit, so the county probably says
Not conforming.
now, can the developer sue the city for all the not
Or the granting the
following
approval.
the
Probably
law, negligent, incompetence, or whatever?
Really? Okay, does that ring true to you? I asked you to do this. I asked you to let me build this, and you did, and now I'm going to sue you for doing it. No. The government has a pretty broad immunity for governmental decisions because they use discretion. And they can make mistakes, and they're not going to, unless something, there are a couple of situations, if it gives rise to equitable estoppel or if it's unconstitutional, that they're going to be made to answer for their mistakes if what they did was a mistake. So, but for the most part, it's, the thing to remember is you need to know what comprehensive plan controls, and that's the one that you're going to deal with. If you have a future land use designation that permits your development, you're not done. It just means you go on to the next step of, does my zoning permit it? And can I make it fit geometrically on my site? And can I build it in a way that I think I'm going to be able to sell? Those questions all come next. But the first one is, what's the land use designation for this property? What does it permit? Can my project work here, or do I need an amendment to the comprehensive plan? First stop. But again, most areas of the state, you're only dealing with one comprehensive plan. Some areas of the state, you end up dealing with two, both the city and the county. So this is the history. This is just a quick walk through the history of how we got here. And now that we have the legislative requirement for adopted comprehensive plans, and they have the force of law, yes, we can make you tear down your project if it's inconsistent with the comprehensive plan. Then the question is, how does this plan become implemented? And we go back to our old friend zoning. Okay, zoning is the most common way that comprehensive plans are implemented. It's a whole packet of regulations. Typically it has its own map. And again, the map, the zoning designation has to be consistent with the land use, but it can be less intensive. And that can be frustrating. That you're held to a lower density or a lower intensity zoning designation than the maximum permitted by the land use, but it happens all the time. So that's how it gets implemented, is what we deal with on a day-to-day basis: zoning regulations, building codes, environmental regulations, subdivision regulations. That's That's how the comprehensive plan can be implemented. And this is another visit to what we talked about this morning, some of the nuisance cases and the origins of land use regulation. And this, we touched on it, but again, this is the point I want you to see. Even in the nuisance cases, where the incompatible use moved to the nuisance, right? The brick manufacturing facility was there before the residential came to it and started complaining about it. The court recognized that a brick facility didn't have to be the end of that city. The city could change its vision, could change the regulations, even though they were there first. There had to be an opportunity to improve the conditions and develop the conditions in a city beyond who happened to be there first. And I see this all the time with airports, again, because I've worked with airports over the years. Residential comes to the airport everywhere, all over the country, and then they complain about the airport noise. Do they lose automatically because they moved into an airport zone? No, they get a hearing, they might get some protection, they might get bought out. The point is that the community has to continue to grow, and there's no clear winners that are going to be winners forever. It's a balancing act. The policies, the competing policies, continue to get reviewed. The elected officials have to do the best thing they can for the time, for the community at the time. And I put these up here mostly to get these quotes. Pennsylvania Coal was an early kind of Supreme Court case that had to do with mineral rights. And the quotation, government could hardly go on if to some extent values incident to the property could not be diminished without paying for every change, but the implied limitation has its limits. When it reaches a certain magnitude, in most if not all cases, there must be an exercise of eminent domain. There comes a point where the burden of the regulation is so heavy that the government can be forced to take the land through eminent domain. And the Supreme Court cases on this don't give us any clear guidance as to where that point is. It's going to be fact specific every time.
Who pays for sinkholes in situations like that where some previous mineral operation was not properly mitigated and then the land was sold to the developer?
Insurers.
Oh, insurers.
And that's the bottom line.
And insurance policies don't have protections for those kinds of events?
You know, it's funny. There's like a whole body of law about sinkhole insurance in Florida that I just refuse to learn anything about. It's just fiddly. There's in areas of the state where they're prone to sinkholes, though, most of the time it's not because of any bad act. It's just because it's just the nature of the substructure. I don't know. There's probably regulations that tell the insurers what they can and cannot carve out of that. But I think there's probably a little bit of strong arming going on that if you want to sell insurance in the state, just like there is with windstorm, you have to offer windstorm. You have to offer some sinkhole protection, but I don't know for sure. Not an insurance specialist. We touched on this earlier, and again, I think repetition helps. That to hear it, be allowed to think about it a little bit, and hear about it again, sometimes helps me remember it. So I'm doing the same thing to you. Nuisance cases was the beginning of land use regulation, but they had their limitations. They could only provide answers for one set of parties and one set of facts. The results could be all over the map, and they wouldn't really provide any clarity for future development of the community. Euclid versus Ambler Realty is really the zoning case of all time. It was the first time there was a separation of use scheme and what we think of as a pretty traditional zoning scheme where the entire town was split into zones and permitted uses were assigned to different zones. This had a pyramidal structure, if I remember right, and you'll still encounter this in zoning codes today. There'll be a general business use, and it permits a long list of uses. And then the next most intense business zoning will say you can do anything. Let's say there's B1, B2, and B3. in B2, you can do anything that's permitted in B1 plus these additional uses. And then in B3, it says you can do anything that's permitted in B1 and B2 plus these additional uses. So it becomes pyramidal, inverse pyramid, I guess. And that was part of the structure in Euclid. So that's how we get Euclidean zoning. That's what it all goes back to, is that Supreme Court case. And in a sense, it had some unintended consequences that we're dealing with now. The premise of a good zoning scheme was to separate uses. Because if you had a brick-laying yard or you had an industrial factory and you had residences, there was no way to protect the residential use from the effect of the industrial use except by separating them. There were no scrubbers that they could put on those industrial facilities at the turn of the century. There was no soundproofing they could put into the home to protect them from the noise of the industrial use. There was no way to have them next to each other and not injure the residential. So the best they could do was to separate them. But separation of uses then became the mantra of zoning. It's what zoning was all about, was separating incompatible uses. And it directly leads to the kind of suburban development that we have today, where residential is separated from business, separated from jobs, separated from schools, which means you can't do anything without getting in your car. And it's contributed to the health effects that we have today of a society that doesn't have to get up and walk anywhere. Did you have a question, or you just nodded? Okay. So now we have ways to make compatible what had previously always been incompatible uses. You can have a pretty serious factory, and because of industrial improvements and environmental design, you can live right next to it. It might never affect you at all. You can live above commercial with no harm, right? Because building methods have improved to that extent. And yet the remnant of separation of uses as a good thing in and of itself remains in our zoning codes. Okay, that's my preaching for the day. The Penn Central case in New York had to do with the use of airspace above the Penn Central Station. And this gives us the language that has become really the most cited standard for regulatory taking. Whether the economic impact of the regulation destroyed the reasonable investment-backed expectations. So if a regulation takes all use, all viable use, all reasonably profitable use, or the reasonable investment destroys the reasonable investment-backed expectations, these are all trigger things to suggest that a regulatory taking has occurred. All right, so we talked about zoning regulations and the comprehensive planning also. It's all an exercise of the police power. The inherent power of government to enact and enforce regulations for the protection of public health, welfare, safety, and morals. You don't see morals too often in that list anymore. To be a valid exercise of the police power, there must be a connection between the perceived harm to be prevented and the requirements of the regulation. Okay, this nexus is really critical to understanding the Supreme Court decisions that have come out in recent years and understanding whether a regulation you encounter with a project could be actually a regulatory taking. There's two sides to the equation and they have to be connected. The first, one side of the equation is what is the harm that is being remedied by our regulation? It's not a valid regulation unless it protects the public health, safety, and welfare. So we think that what you're proposing in your project is going to damage the public health, safety, and welfare. We're going to regulate it or restrict it. That's the first half of a valid zoning regulation. And then there's the other half. It must be, there must be a connection between that harm and the requirements of the regulation. So if you read the Coons case, you saw some of this. He was required by the Water Management District to mitigate wetlands far from his project. That was one of the things that the Supreme Court objected to, right? So or someone is gonna do a project that has a big traffic impact, but they say, we'll allow you to do that if you contribute to parks. There's no nexus. The impact of the project on traffic cannot be mitigated by parks. There's no connection. So both of these things have to be in place for a valid regulation. The regulation has to advance the public health, safety, and welfare, and it has to restrict or control the thing that endangers the public health, safety, and welfare. That's the nexus that we need. And we see this in the Nolan case, a Supreme Court case. This was California.
Nolan Dolan.
Nolan and Dolan, yep, they're a pair that you need to remember. So the Nolans sought to demolish a beachfront bungalow and construct a new house, and the Coastal Commission, which was an extra layer of regulation out in California before you could build on the beach, required as a condition that they dedicate land, a lateral public easement parallel to the ocean across their property. So are you picturing this? So we have the ocean. You'll learn that I'm not a good artist. And we have a lot like this. And we want to, I don't think there was a seawall. I think it had beach access. So we have a bungalow, but we want to demolish it and build a house like this instead. And the Coastal Commission said, as a condition, okay, you need to give an easement for public access across the entire beachfront, like this. And the court held that that was an invalid condition. There must be a rational nexus between the legitimate public purpose and the condition. So unless the permit condition serves the same governmental purpose as the development ban, the building restriction is not a valid regulation of land use, but it's an extortion. Because the idea, what the California Coastal Commission was trying to do was preserve views of the ocean. And this wasn't going to do it. Something like this, or narrowing the same, they're like, no, you got to pull it in farther. Those kind of regulations would have advanced the public interest that the California Coastal Commission was charged to protect views of the ocean. Giving people a path to cross the beach that was otherwise privately owned, that didn't advance that governmental interest at all. It was just an exaction. It was just something they wanted for some other public purpose, but it didn't advance the purpose that they were created to regulate.
They didn't try and say that you gotta give them public access to the beach to get there, or?
It was this, what they required was this parallel to the beach.
Okay.
And it didn't, the Coastal Commission, they had regulations that said they were supposed to review these projects, and they could impose conditions that would advance the regulatory interest that they had, which was to preserve sightlines of the beach. But this condition didn't do that. So there was no nexus. Maybe that's a good thing to do. They could have condemned it. But it wasn't reasonably connected to the purpose that the Coastal Commission was supposed to be reviewing the project for. Okay, that was a bad grammar, but
It was like a far reach.
yeah, there was no nexus. And then in Nolan, the other one that you'll need to remember, this was the hardware store, right? Yeah. So Dolan wanted to expand her hardware store and pave the parking lot, and the city required as a condition that she dedicate land for a greenway along an adjacent creek and install a pedestrian and bicycle pathway. It was a pretty small project that she was proposing, and the Supreme Court held that the essential nexus was there, but the degree of their demands didn't bear a reasonable relationship to the impact of the proposed development. So if all you're doing is adding a few hundred square feet to your hardware store, that alone wasn't creating an impact that justified the tremendous dedication requirement that they were imposing on her. That was the deal. So the two things we have to remember, and you'll encounter these, you'll think about these when you read the conditions that cities impose on your projects. Is the condition or the exaction, that is a fee or a dedication requirement, or shorten your building, or enlarge your side yards, are those requirements related to the public health, safety, and welfare? And is it a rough proportionality to the actual impact of my project? Those are the criteria. And the Coons case, which was decided a couple years ago, came out of Florida from one of the water management districts, Southwest, to the state Supreme Court, and then the state of Florida Supreme Court was overruled by the U.S. Supreme Court. It extends the Dolan and Nolan holdings to cases where no actual exaction of land occurred. And this was a requirement that Coons contribute land, put land in a permanent undeveloped state, and do off-site mitigation, if I'm remembering right. I haven't read it in a while now too. And the court found that these demands, even though he never actually did what they were demanding him to do, that the demands were extortionate. And they're saying, this is the part that I like. Development, you can't impermissibly burden the right not to have property taken without just compensation. Is that, you get it? That they can't, even if you don't, if you're made to give up land without a good reason, that clearly you can see that as a taking. You've given something up. But if they condition it in a way, and you don't comply with the condition, but you're denied your approval because of it, then they're conditioning, you have a right to make reasonable development of your land, but the conditions that they've imposed on you that you've rejected have taken that right from you. So even without the actual loss of land, just the imposition of the extortionate condition was enough to create a taking. And it felt good for everybody involved in the development process to see this decision come out, because we encounter that all the time. When they're like, contribute to this? Fine, we'll just find a reason to deny you. And whatever they're asking us to contribute to has nothing to do with the impact of the project. So local government has the DNA within it to push their powers into this sort of extortionate setting if they're not controlled in this way. So it felt good as a development attorney to read this. All right, so this is just a review again. An exaction is a condition imposed as a prerequisite for receiving a development approval. There are all kinds of them. To pay impact fees, to dedicate land, to pay for school seats in the school, to install sidewalks. There are all kinds of conditions that will be imposed on a development. But there must be a rational nexus between the harm or the impact of the proposed development and the condition that is imposed. And there must be rough proportionality between the anticipated impact and the exaction. This is what we get from Nolan, Dolan, and Coons. Questions? I know. Who doesn't have questions about constitutional law decisions that run hundreds of pages long?
Besides the exactions, a lot of times the developer will willingly maybe give up a piece of land, create a park, to aid in the process of approvals, and that's just a goodwill thing.
Well, that's essentially then a business decision, okay? And we saw it happen a lot in the 80s with school sites. Every single suburban developer they were ready to give money for school sites, or to give land rather, for school sites, because they wanted those schools in their neighborhood, because that was a marketing tool. And the same thing will happen with parks. that if it makes sense for the developer financially, because the park or whatever they're giving will be a marketing tool or a benefit to their community, then they build it into their pro forma and they move on, whether there's a legal basis for the exaction or not. So those business decisions are made all the time.
And those are concurrency issues now, correct?
If the exaction would pass this test, concurrency cannot become, must also, a concurrency regulation, the way that it's implemented, must also pass this test to be valid.
In the city of Marietta in Georgia, in the newspaper, that same open discussion took place, and the board ended up voting, the commission board 5-0 to let it go along. Because based on the existing site plan or comprehensive plan, it was okay to have a certain ratio. Then all of a sudden, they came up with this requirement that they should do an open space development, and they should change the ratio, which would drop the amount of houses, units that they could put per acre. And they tried to turn on the plan. They actually expected to be denied. And then they retained an attorney, and their argument was the city was not in the business of making the developer's project more profitable. So when the attorney was finished arguing the case, he said neither, he had it right there, neither was the developer in the business of losing money to please the aesthetics of the community. Where the existing blah 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 is not consistent with it, and they end up voting 5-0 to approve. But it was interesting to hear you say this.
Similar language, huh?
Yes.
No, I mean, developers make concessions all the time, and it's all a matter of
Expediting.
right. Do you want to have this fight? Do you want to have this 7-year litigation? Can you still make your project work if you drop the height by 2 floors, or you carve out the park and give it to them, or you widen the sidewalks by 2 feet and create a public plaza and give them a bus bench? It's like, and most of the time you find a way to make it work without having to challenge this, without having to take it all the way to the edge. Sometimes it doesn't, or sometimes there's folks like this guy Coots who was just, he wasn't going to yield on this. He saw it as an extortionate demand, and he went to his deathbed and would not yield to this demand. And so I have seen it go both ways. Trying to think of other good examples.
I mean, the thing is, sometimes when you go in to develop things, it's like these counties are so poor, they have no money. It's like, look, we're going to give you all this money. So yeah, we'll kind of concede a little bit, but we're helping you out too. So, I mean,
you hope that that there's not flat out bribery going on. You do. And if it's for a public benefit, there's absolutely no rationale, but a developer is offering something that the community sees as a benefit, they will get on board. They just don't bother to go back and change the regulations to match it.
So speaking of extortions, City of Pembroke Pines has a land utilization fee for open land. So I guess it's kind of rare to see both sides that if there's an open land that's already zoned for a type of use, you go ahead and put up a contract and want to do development, you have to pay that land dedication fee for the reserved green space in another area for the space you just occupied. So to me, it's a little gray area there, because why would it be zoned for development and they're going to charge you a fee just to reserve that green space somewhere else? So that's.
I wonder if that's all there is to it, because that would puzzle me also. I mean, it can be open space, a percentage of the site being retained in open space is a pretty traditional part of zoning regulations. Allowing you to build over that threshold by mitigating, providing open space somewhere else, maybe I can see that. It's done with wetlands all the time. You're allowed to fill wetlands because you mitigate somewhere else. You provide the same function as the wetland in another location. There have been, the city of Hollywood for a long time had a park dedication requirement that simply required dedication of a portion of a residential project for a park. And they eventually realized they didn't want a bunch of little minuscule parks here and there and the other, so they moved to a more traditional park impact fee. And it was similar in that you didn't have to put a park in your residential project, but you could contribute to the city so it could buy land and assemble it for a park somewhere else. So maybe the open space function is being treated the same way. I don't know that particular city's regulation. But I doubt that it's probably a way of providing the open space that would otherwise be required for the project and providing it off-site.
Yeah, unless maybe Mr. Cohen.
Yeah.
I don't remember, I thought it was based on acreage at the site, certain dollar value per acre, and they just dedicated that somewhere else. So maybe I'm just confused.
Yeah, and maybe, I mean, I am endlessly impressed at the creativity that city attorneys develop in finding ways to get what their cities need through the development project. So maybe it's exactly as you're describing, and I'm just not familiar with it. But almost anything like that could, in theory, be provided off-site if it's not specifically site-related. Certain things like access to the road have to be designed on the site to meet certain standards. But other things, open space, green space, parks, trees, you can make a decision to put the trees somewhere else, and the community still gets the same benefit. So I don't see a harm in that. So the exaction, this is an important thing to remember, the rational nexus, the connection between the harm and the rough proportionality, and that the source of these come from Nolan and those Nolan and Dolan cases, and a little bit of the basics, the facts of the Coons case, and how it extended the Nolan and Dolan tests to the improper exaction that was never paid, actually.
Who defines a rough proportionality? That seems like it's kind of vague.
It is another one of the difficult things about land use litigation is the uncertainty of it. The courts all use language like rough proportionality and fact-specific findings. It's really very difficult to anticipate what the outcome of that litigation is going to be because of these are not hard and fast rules. And they can come up with conflicting outcomes in the court cases. Another reason to find a way, and sometimes you acquiesce to what might be questionable requests from a city in order to avoid the litigation, get your project done, make a fair return on it, and move on. Okay. I want to take a quick, 10-minute break, and then we'll come back and I'll decide what I'm going to do next. I'm tired of being wasted. You okay?
They might. I might get one. You might have to. All right. Yeah.
I know, but people get that hurt.
Do most of the time.
That's our natural resources. And eventually.
No, but doing that, putting it on YouTube is a great. Yeah, it really is.
Yeah, the beaches, the everglades, sensitivity of our environment to uncontrolled growth eventually got legislators from all over the state, which might as well be in a different state.
Friday,
If
that
you're
way
in
you
Jackson,
can-
you're in South Florida, it's like you're intervening in your interests.
I start but he.
Next is the idea of where schools So when I talk about there's a nexus, there has to be a connection. The impact of the development and the demands you're making, it has to be a connection. Logical connection. If someone is creating traffic impact and you ask them to dedicate land, those are two different rails. Right, they never cross because putting more traffic on the road has nothing to do with what you are. So your nexus is the thing you're trying to tackle and what you're asking for is your demand you have to coincide.
What do you guys think? My understanding of the process, get with her, use the same list, she'll agree to us, and see
Well, it's a different topic than land use due diligence, because land use due diligence means what exists right now? What could I build right now with it's kind of backwards. You're talking about planning.
Hi Mark, this is Saturday today.
As long as it's not a planning class, it's land use. So if what you did was about changes that would be necessary to the land use regulations apply to your use, that would be okay. Again, it has to be about land use regulations, not just land use planning. Yeah, I know, but I'm not that concerned in that research paper about why that would be a project. I want you, it has to be about regulations. It has to be about how, what changes to the regulations. Yeah, it's not a research paper about a great project. It's about the topic of land use regulations. Zoning the land use regulations. It's more about the regulations. Yeah.
I mean, that's good. Oh, you paid this one? Oh, that's good. My friend did the same thing. Hey. And he's just graduated.
change something about their business or and but because of the situation of the said I'm not building yet, so in 2009 he introduced.
Yeah, this is, two of these classes are in,
And he can't use the 7 years, and he said, listen, I'm not asking you for anything, that's what that was given to me. When you want.
Well, I mean,
Well, what is it?
there's nothing, the city can decide to change the land. Nothing had been built, right? You just had plan, you just had prior approval.
But he had spent money.
That comes to equitable establishment. The principle is called equitable establishment. When the city can change its mind, and they can take away what they've given previously. Unless the facts rise to the level of equitable establishment. That is, you've acted in reasonable reliance on approvals given to you, you've expended significant money in reliance on those approvals. So if the facts are right, and it's all equitable establishment, then the city will be prevented from going back on its prior approvals. But if those facts aren't there, then they can change their mind. They can simply decide, we're gonna downsize, we're gonna reduce costs.
And then the Brickell City Center. That's phase 3 of the
Yeah, that's what we're looking at also, we're looking to set up.
That's what I'm talking about. All these big developers came in and they didn't bring in these remedies for the transportation problem. And once that problem
They changed, you can see really a market for it, it's just an urban, tiny design. They changed everything about the
I don't want to be here,
area.
but I need to
For instance, commercial here.
Florida doesn't get
Residential here, in order to story crime or to, it's a different place.
The transit facility, they don't have the money to do the infrastructure.
Are there so what would
It does change, has to change the regulations.
I like my job, that's what I have. Some departments.
Boundary transportation.
Yes, some people have actually
Comprehensive
like,
or
they interact like
urban redevelopment for an area becomes financial planning, federal budget.
There's something.
I mean, if you want to write about a situation where it's kind of, American city, but how they did it,
Because right now it's
how they did it. And I'm more concerned about the regulations, remember this is a board of law. This isn't an industry plan,
Because
if you can get information on how they allow that, and we've got this in regulatory structure, for example,
what they have
a market in a residential area, adopted these regulations that allow how do they control it? If you want to do that, I mean, it's similar things for temporary uses in the northeast area of the city of Fort Lauderdale, and they may have temporary, or with even sidewalk communities, they'll allow them in an area on a temporary basis. Nobody gets to invest in it. And they're sort of letting everyone know that this might not be permanent. So that was one restriction. But if you want to look at how to approve something like that, how other cities have done it in an existing regulatory structure. I have to decide what I'm going to do next as my lecture.
That's so sweet.
It's going to be through the reading out of this session, we'll send it out to
Oh, right. It's just like, you know what?
yeah.
This is kind of stuff.
I'll be in Philadelphia in December.
I can see that. And I'm gonna sell one.
I mean, that's how the county board of land. Three places they have one.
You know why they were white girls? Comes out dark.
Any horizontal search.
This particular lot is
Well, and let's talk about land use designation and not zoning. We're talking about land use designation as opposed to. Use the term zone.
Master city planner.
Land designations, we're trying not to take distinctions. So if the land use designation is residential and permits the
She looks like it's a personality.
She was trying to get coffee. I looked over at you, I saw the one I looked at me, Mark was to give I did that even back in the old classes. I did that sort of stuff.
I mean, there's no way around it. It is what it is.
I know.
I've seen her just walking in the hallway for 10 minutes and like going over one of those
That's
chairs.
what you
Little break. Yeah.
Yes, obviously, you're good.
No, all that would have to do with is report. If the city land use
He said it was something
I knew that happened to me in Texas.
He said it real slick too. You have to be listening to
I know, I changed my style. of my PowerPoint. This would be review. This is review that I probably would have planned on doing at the beginning of the next class, but I'm still adapting to these very, very, very long class days. But first let me ask you for questions. We've covered a lot of things that may be really unfamiliar to some of you, but do we have questions from from what we've done, what we've been talking about.
I just have a general question. Out of all the counties that you've worked in Florida, which ones have been difficult to work with, and which ones have been easier, or has it been like that? Some counties don't want development, some counties are like, yeah, we love it.
No, Martin County is more difficult.
Okay,
Experienced and heard that.
I have heard, yes, that Martin County is much more difficult than either of its neighbors. Yes, that Palm Beach and Port St. Lucie County are both better for development than Martin County.
Our county's pretty bad.
Broward
Which
County,
town is that?
Broward County is very difficult. But then again, I'm like buried in the minutia here. This is where I live, so this is where I work most of the time. I have heard, now I have not worked, I haven't done like a from its inception project in Osceola County. I've done some diligence investigations in Osceola and some where our client has bought out like the remaining parcels of a larger development and things like that. But I've heard from our folks in Orlando that Osceola, that's where, you know, it's right next, it's near Disney World, has been terrific. And some of the big developments that are coming, that are still coming out of the ground are coming out and are getting built in Osceola. So I've heard they've been very cooperative. But
Disney
again,
paved the way, I guess.
hmm?
Disney paved the way.
Yeah, Disney's a whole nother story. They like pretty much created their own government. With the